We have several justices, such as Justice Datiba, Justice S.A. Brube, a whole lot. Time will not permit me to mention all the past Chief Justices and Justices of the Supreme Court who have served this nation with distinction. But history will forever remember each of them, and today we celebrate them all, even if not individually named. Today's celebration is not only about longevity, it is about resilience, integrity, and commitment to justice. The Supreme Court has for 150 years remained the final guardian of our Constitution and a symbol of judicial independence. As we celebrate the present, we commend the current Chief Justice, His Lordship Justice Paul Bafo-Boni, and all the justices of the Supreme Court for their dedication in strengthening judicial independence, improving access to justice, and embracing technology in court administration. Their leadership continues to inspire confidence in Ghana's justice system, both at home and across Africa. JUSAC is proud to be part of this journey. Our members, who form the backbone of judicial service, remain committed to professionalism, efficiency, and excellence in service delivery. Behind every landmark judgment is the silent but vital support of hard-working judicial staff who keep the wheels of justice turning. As we look to the future, we must continue to invest in people, innovation, and better conditions of service for both judges and judicial staff. We must strengthen institutional capacity, deepen digital transformation, and ensure the welfare of all who serve in the justice system. A strong and supported workforce is essential to sustaining the integrity of our courts. Your Lordships, distinguished guests, JUSAC reaffirms its support for the entire judicial system. As we honor the past and celebrate the present, let us work together to define a future that strengthens justice and serves every citizen with fairness and dignity. Congratulations on 150 years of excellence. May the next chapter be even greater. Thank you.
Thank you very much, the President of the Judicial Service Staff Association of Ghana. We're taking more solidarity messages because we're the judicial service, the judiciary is in this together with a lot of partners, so kindly bear with us. We will next call on the President of the Ghana Bar Association, Mrs. Ifwagate, to give a solidarity message. Please, let's do it better for the first female president of the National Bar.
My Lord, the Chief Justice, Paul Bafo-Boni, the special guest of honor, His Lordship Justice Yawapao, Madam Chairperson, Her Ladyship Justice Sofa Akufu, the special guest, Right Honorable Professor Reverend Dr. Michael Aaron Okwe, former Chief Justice, Her Ladyship Justice Theodora Georgina Wood, the Chairperson of the Council of State, Right Honorable Do Ajaho, my lords and ladies, spiritual and temporal, the Honorable Deputy Chief of Staff, Nana Oye Bampoado, the Honorable Deputy Attorney General, Dr. Justice Sremsai, representing the Honorable Attorney General, Dr. Dominic Ayeni, His Royal Majesty, Ni Ayibunte II, Bese Manche, and Adonting of the Ghana State, Nime Kename, my learned friends, distinguished ladies and gentlemen, our friends from the media, good morning. We have, by God's grace, gathered here today to launch the 150th anniversary celebration of the establishment of the Supreme Court. As president of the Ghana Bar Association, my colleagues and I are excited to be part of this event, as the bar, for several reasons, has a well-vested interest in the celebration of this historic milestone in the annals of the bench. Describing the bench-bar relationship, Justice R.J. Kochar of the Supreme Court of India in the case Gupta versus Ramurthy, a 1998 decision, stated as follows: the bar is the mother of the bench and the bright mirror of judicial officers, whose image, character, and conduct is correctly visibly reflected therein. And it is for the bench to nurse and nourish the merits of the bar, unquote. Indeed, before the introduction of imperial law by the Supreme Court Ordinance of 1876, which we celebrate today, a bar existed in the Gold Coast. David Kimball, in his seminal work, A Political History of Ghana, 1850 to 1925, chronicled the evolution of the Gold Coast legal profession. His work spotlights the first 7 self-taught African attorneys or legal practitioners: James Hatton Brew, Charles Bannerman, Charles Henry Battels, George Kuntu Blankson Jr., William Charles Spilsbury, and W.A. Ward of the Gold Coast, who started the legal profession from 1864. Kimball notes, distinguished ladies and gentlemen, that the introduction of the Supreme Court Ordinance in 1876 gradually wiped off the 7 self-taught attorneys and the ones that followed. That's Edmund Bannerman, Samuel Bannerman, and George Emisa, and led to the emergence of professionally trained lawyers and solicitors from the Inns of Court. Thus, 1876 is not just significant for the establishment of the Supreme Court, it is also significant for the bar, because it marked the beginning of the era of formal trained lawyers in the Gold Coast. The theme for the celebration is honoring the past, celebrating the present, and defining the future. Respectfully, as we join the bench to launch this momentous celebration, we ask ourselves very simple questions. Where would Ghana be without the rule of law, safeguarded by the bench and the bar? Would the scenery be that of the survival of the fittest? Are we fulfilling our God-given responsibilities? That is why we must continue to remind ourselves, both the bench and the bar, that we find ourselves in a hallowed position, a position of immense power and influence. May we be humbled by this and dispense justice to all men and women without fear or ill will. In 1976, on the centenary of the Supreme Court Ordinance, His Lordship Samuel Azukrap, the then Chief Justice of the Republic of Ghana, delivered the speech at the Supreme Court Centenary Celebration, which is from 1876 to 1976, and he observed as follows: if our legal history has been eventful in the past century, we can also say that we have been lucky in the people of our nation who have been alive in every generation to match the grandeur of the events of their time. We have in these years past never lacked a hero in the law to speak for our people. A Casely Hayford to warn the imperial power to keep our lands inviolate. Emensa Saba to plead the people's cause in the highest councils of empire. Ekusi to guide in the writing of our first constitution towards independence. In our own lifetime, Edankwa to keep us reminded of the need for self-discipline in the tumultuous years immediately after independence. And Kosa to hold first among our people the scales of justice evenly between the government, the legislature, and the people. As we honor the past, so ably described by Chief Justice Azukrab, let us in the present be resolute in our defense of the rule of law, be true custodians of the sacred trust reposed in us by none other but the Lord Almighty, to whom we are all ultimately accountable. This will define our future. I thank you for your kind attention, and God bless you all.
Thanks are due to the President of the Ghana Bar Association for this robust speech. Ladies and gentlemen, it will be a travesty of fairness if we do not mention these names. Former judges of the Supreme Court. Justice Duse is here. Let's see him. Justice Duse. Justice Pegan. Justice Pegan. Thank you, sir. Justice Pegan. Justice Atuguba is here. Justice Atuguba. Justice Irene Labi. Irene Labi. Justice L.L. Mensah. Justice Mele Wood. Justice Kofa Adai. Justice Onyanuga. Justice Joseph Akamba. And Justice Vida Akoto Bamfu, retired judges of the Supreme Court. But first of all, are judges who are still sitting. Justice Surubare, Justice Akar Boafo, Justice Hafisata Amaliboba, and Justice Enet Gau. Welcome these persons. We'll proceed with these messages, and it is a time for us to invite the Association of Magistrates and Judges of Ghana. Welcome this group.
My Lady Chair, please permit me to stand on the existing protocols. I consider it both an honor and a privilege to extend the heartfelt congratulations of the Association of Magistrates and Judges of Ghana to the Supreme Court of Ghana as it marks 150 years of exemplary service to our nation. We proudly celebrate the Supreme Court of Ghana at 150, honoring a legacy of justice, integrity, and unwavering service to the nation. For generations, the Supreme Court of Ghana has stood as a beacon of hope and a guardian of the Constitution, inspiring confidence in the rule of law and shaping the course of our democracy. While commemorating this historic anniversary, we honor the vision, integrity, and dedication of the distinguished jurists, past and present, whose service has upheld accountability. Their enduring legacy continues to inspire all members of the bench and bar. Now, while reflecting on this remarkable journey, we are reminded that the strength of our judiciary lies not only in its history, but in its continued courage to uphold truth and fairness. With renewed purpose, we look to the future, confident that the Supreme Court of Ghana will continue to lead with wisdom, uphold justice without fear or favor, and inspire generations yet to come. As colleagues in the administration of justice, we express our solidarity with the Supreme Court of Ghana and reaffirm our collective commitment to judicial excellence, independence, and integrity. Together, we will continue to uphold the values that define our justice system and serve the people of Ghana with honor. So congratulations on this remarkable milestone. Congratulations on 150 years of excellence. Long live the Supreme Court of Ghana. Long live Ghana. God bless Ghana. Thank you.
Thank you very much. We'll continue to take more solidarity messages, but let me kindly inform you that this event is live on GBC and UTV, and it's also being streamed live on GH1 and Star FM. We have a number of media persons or media outlets covering this event. Permit me to acknowledge the presence of some more special persons in our midst. We have former Chief Justices, Sophia Akufu. First, we heard her speak as the chairperson for today's occasion. Ma'am, we're grateful for your presence here. We also have Justice Theodora Georgina Wood in our midst. We're grateful for your presence here, your ladyship. We have in our midst former Attorney General Godfred Yeboah-Dame. We also have Honorable Sam Okujeto, former Bar President and Council of State member. Thank you very much, sir. Mr. Anthony Forson is a former Bar President. Thank you for being here. We have, for our protection, and we see them, the visible police presence, we have the Commissioner of Police, Mr. Joseph Okulu-Jamra, the Director General of Legal and Prosecution. He is representing the Inspector General of Police at this event. And we are being hosted by the premier university of this nation, the University of Ghana. It's only fair that we acknowledge the persons of authority who have graciously offered this auditorium to us. Professor Joseph Yao is a Provost, College of Humanities, University of Ghana. Professor Ni Adi Kujo, Provost, College of Education, University of Ghana. Professor Mavis Dakonjeke, Dean, School of Social Sciences, University of Ghana. and Dr. Sarilyn Amwa Buampong, Head of Department of History, University of Ghana. We'll continue with our solidarity messages, and we'll take one from the legislature, the Parliament of Ghana. And I see Honorable Jerry Ahmed Shaib, my classmate and friend. Honorable, please let's welcome him.
My lady chair, ni ayibonte, bese manche and I don't any of the Ghana state, ni me na me. My Lord, the Chief Justice of the Republic of Ghana, Justice Paul Bafon-Boni, the Director General of Ghana Prisons Services, former Chief Justices, former Speakers of Parliament, the Deputy Attorney General, our venerable judges of the Supreme Court, esteemed judges of the judiciary, distinguished dignitaries, the President of the Ghana Bar Association, cherished citizens, ladies and gentlemen. I'm sincerely grateful for the opportunity to speak on the theme, the Supreme Court of Ghana at 150, honoring the past, celebrating the present, and defining the future. It's a theme that captures the very essence of our journey as a people. It reminds us that the story of our Supreme Court is not merely institutional, but deeply historical, shaped by towering figures who across generations defended the sanctity of justice, even in moments of political uncertainty. From the foundational leadership of Kobna Akukosa, who upheld judicial independence in the early years of our nationhood, even at great personal cost, to the transitional stewardship of Edward Akufo-Addo, who guided the judiciary through a critical post-school era and embodied the bridge between law and national rebirth. The court has remained a pillar of continuity in Ghana's constitutional evolution. We recall the unwavering service of Fred Kwesi Apalu, whose judicial courage endured through turbulent periods of military rule, reinforcing the idea that justice must remain constant even when governance is not. In recent memory, the transformative leadership of Georgina Theodora Wood stands out prominently. As the first female Chief Justice, she redefined judicial administration through reforms such as the Alternative Dispute Resolution, ADR, and specialized courts, strengthening access to justice and efficiency within the system. Alongside these historical pillars, the modern era under Chief Justices such as Kwesi Enin-Yeboah and Gertrude Tokonu reflects a continuing commitment to institutional strengthening and constitutional fidelity across successive administrations. Much like the pilgrims in the Canterbury Tales by Geoffrey Chaucer, who journeyed together toward a shared destination while telling stories that reflected their values, struggles, and hopes, our nation's legal journey has been one of a collective purpose. Each generation, like those pilgrims, has contributed its own chapter, some marked by sacrifice, others by triumph, but all moving together in pursuit of justice and order. As we mark 150 years of the Supreme Court of Ghana, we pause along this journey, not only to reflect on the stories of our past, but to take stock of where we stand today and to define with clarity and courage the path that lies ahead. For 150 years, the Supreme Court has been the guardian of our Constitution and the defender of our freedoms. We honor the vision of our founding fathers and jurists who laid the foundation of justice in this land. Their courage reminds us that democracy is never handed down. It is earned, protected, and preserved. We cannot forget the landmark decisions that shaped our democracy. These decisions strengthened the rule of law and reminded us that justice in Ghana is not for the privileged few, but the right of all. They are a proof that the court must remain impartial, an impartial arbiter of our collective destiny. As we celebrate the present, let us also safeguard the court's independence. The judiciary must never be dragged into partisan politics. Its strength lies in neutrality. The judiciary's strength lies in neutrality, in their ability to interpret the law without fear or favor. When the court stands above political interference and exercises its authority with restraint and fidelity to due process, it preserves its integrity and ensures that justice continues to anchor our democracy. Together, let us declare, hands off the judiciary, respect the Constitution. Looking ahead, we must define the future with boldness. Let us modernize our courts, embrace digitalization, expand access to justice, and strengthen legal education. Let us build bridges of collaboration between Parliament, the executive, and the judiciary, each respecting the boundaries of the other, yet united in service to the people. To the next generation of lawyers and judges, I say this: carry forward the torch of justice with integrity, courage, and humility. The Supreme Court is more than an institution. It is a symbol of hope, fairness, and the enduring promise of democracy. You are the custodians of that promise. As we honor the past, celebrate the present, and define the future, let us unite in our resolve to protect the sanctity of justice. Together, we can ensure that the Supreme Court of Ghana remains a beacon of truth and fairness for centuries to come. God bless the Supreme Court of Ghana. God bless our great nation, Ghana. Thank you very much, and God bless us all.
Thank you very much, Honorable Jerry Shaib of Parliament. Ladies and gentlemen, there is a further assemblage of names, renowned individuals who should be mentioned. Ladies and gentlemen, you will welcome former Deputy Attorney General Diana Asunabadapa. Welcome her. Diana Asunabadapa. His Royal Majesty Dr. Ni Aibonte II, I think he's been acknowledged. He's a Besse Manchin and a Daunting of the Ghana State of Ghana. The Speaker of Parliament is also here. The Vice Chancellor of the University of Ghana. The members of the Council of State. Right Reverend Dr. Daniel M. Toto, Anglican Bishop, and we have seen him. The representative of the National Chief Imam, Arimiyao, is here. Mr. Fogati, the National President of the Ghana Bar Association. Mr. Anthony Forson, the former Bar President, of course, members of Council of State, the Judicial Council, General Legal Council, Parliament Select Committee on the Judiciary, all judges and magistrates in the Greater Accra region. Ladies and gentlemen, we shall now invite for more messages. This time, message is coming from the Attorney General of Ghana. Welcome the Attorney General of Ghana.
Your Leadership Chair, may I stand on the existing protocols? last week I was on the internet and I chanced upon some news items. It came after the launch, the press conference by the chairperson of the anniversary organizing committee. And some of the headlines read, and I would read from, one says, Supreme Court hailed for defending Constitution ahead of 150th anniversary. Then another read, the Supreme Court commended for defending Constitution. So I went into the stories to find out who was giving the recommendations and the hailing. And it was His Lordship, the ever affable, distinguished Lord Justice Richard Ajay Frimpong. Then it took me back to a statement which C.J. Azukrab wrote as part of his foreword on the centenary anniversary of the judiciary. It was published in the University of Ghana publication in 1976. My lady, with the permission, I'll read. A centenary is always a good opportunity for a survey in retrospect. But when such a survey is made by the celebrants themselves, they run a risk of appearing to be patting themselves on the back. So I discussed that with my boss, the learned Attorney General, who appointed me to come here and pray your lordships to expunge Justice Frimpong's message and put mine on record. The Supreme Court, contrary to general understanding, is not the current Supreme Court that we have. It is the entire judiciary which was established. So our friend journalists, it is not the 150th anniversary of this Supreme Court, it is the 150th anniversary of the entire judiciary, which was established after the repeal of the first Supreme Court ordinance, which was in 1853, and then the establishment of the second Supreme Court ordinance. The Supreme Court, therefore, has sustained itself for 150 years. But the Supreme Court has done more than sustaining itself for 150 years. It has sustained itself and has sustained the current legal order for 45 years. And when I say 45 years, I'm not counting from the political science point of view. I'm counting from the pure theory of law, Kelsonite's point of view, which says that the Grunum is the foundation of the legal system. Therefore, I counted from 1981, 31st December. The Supreme Court was not always like this. In other words, the judiciary was not always like this. When the ordinance was passed, it did not just establish courts. It gave prescriptions for the judges who would work in the court. It also prescribed their salaries. So, for example, a dispatch from Lord Kavanaugh at the Office of Administering the Government of the Gold Coast, dated December 12, 1976, reads, Her Majesty has been pleased to appoint Sir David Chalmers to be the Chief Justice of the Supreme Court at the salary of £1,800 per annum. Mr. James Marshall, £1,000 per annum. And Mr. Thomas Jackson, £900 per annum. That is not all what the law did. The law also established how the court is to empanel itself. So, for example, a single judge of the Supreme Court could hear and exercise the jurisdiction of the court. However, there was an appellate panel which was to be made up of at least 2 judges, including the Chief Justice. And in some important cases, the law allows all the members of the court to be empaneled. In the case of Benyin and Danchi, 1903, Wren Law Report 287. It's also reported in volume 2, G&G, at page 11. This was a case where the Supreme Court, all the members of the Supreme Court empaneled, and they were 4. And the decision went 2 either way. And the law did not make any provision for breaking that tie. The point I'm trying to make is that the Supreme Court has evolved to the point where we are able to resolve all disputes without such a tie. But the Supreme Court has done more than that. We have some facts which are not disputed. We know certain things. One of them is the fact that a democracy cannot exist without rule of law. We know that rule of law cannot exist without an effective judiciary. Therefore, the fact that we have survived for this number of years without any interruption in our legal order is a testimony to the achievements of the Supreme Court. And we all must hail, in the voice of the journalist, and commend the Supreme Court for this great achievement. My lords, there are challenges ahead. Jury trial is considered as the palladium of liberty. We have reached a point where I believe we are having a conversation on whether to abolish jury trials or not. The role of the Attorney General sometimes overlap with the role of the judge of the justice system. So when I speak to your lordship, I speak to myself, and when I speak to myself, I speak to your lordships. Now, may I speak to myself? We do not think that jury trial should be abolished. We believe that technology has come and would assist us to improve jury trial systems. So, for example, we have the digital address system, we have the national identification system, all of which will help us to be able to diversify the jury system and to also educate the populace to understand that justice cannot be fully done without the participation of the people. My last message for your lordships is that in the case of Salah and Attorney General, your lordship had a question which your lordship answered. In that case, your lordship was supposed to decide between upholding a reality as against a legal theory. In other words, the question was whether your lordship would favor that which was actually built as over that which the law said was built, even though it has already been built. Your lordship chose the better option, that the courts is for real people and will look at what has actually been built rather than the product of legal theories. Now, this is the question I leave with my lords. The Supreme Court ordinance was actually passed on 31st of March 1876. However, it became effective on April 4th, 1877. The question is, are we celebrating the enactment of the law or the actual existence of the courts? on this 150th anniversary. A.N.E.A. Misa wrote this in 1976 during the centenary anniversary. He said, and lady, with your permission, I quote, "The ordinance, however, for reasons to be given later, was not brought into operation until April 1877. Thus, strictly, 1976 is the centenary not of the Supreme Court, but of the enactment of the Supreme Court ordinance establishing it." Respectfully submitted. Thank you very much. Long live the judiciary of Ghana.
I hear the whispers in the corridors. The hornet's nest has been stirred. The debate will rage on beyond today's event. May I kindly remind all present that this program is on GBC and UTV and is also being streamed live on GH1. So those who are not here present can also get onto these outlets to witness what is happening here. We'll take another solidarity message from the office of the president, and we welcome Nana Oye Bampo, the deputy chief of staff. You're most welcome.
Thank you very much, and thank you, Justice Remsai, for stirring the hornet's nest. The chairperson, Lady Justice Sofa Abna-Boafo Akufu, my Lord, the Chief Justice of the Republic of Ghana, the chairperson of the Council of State, Justices of the Supreme Court, President of the Ghana Bar Association, the Honorable Deputy Attorney General and Minister of Justice, His Royal Majesty Ni Ayibonte VI Besi Manche, distinguished members of the bench, the bar, invited guests, ladies and gentlemen, on behalf of the President of the Republic of Ghana, His Excellency John Dramani Mahama, and the government of Ghana, I bring you very warm greetings and congratulations to the judiciary of Ghana. 150 years for an institution that carries the weight of justice every single day. This is more than a celebration. It is a moment to look back with honesty, to stand in the present with gratitude, and to look ahead with purpose. A few reflections on the Supreme Court and judiciary over a century and a half. The Supreme Court traces its formal history to the Supreme Court Ordinance of 1876. A lot has been said about this. Final appeals first went to the West African Court of Appeal, established in 1928, and beyond to the Judicial Committee of the Privy Council in the United Kingdom. The law was decided far from our shores by people who had limited knowledge of our sense of what justice should be. Therefore, the establishment of an indigenous Supreme Court in Ghana brought the law home. It was a statement that Ghanaians had the right to determine their own affairs, including the most serious affairs of justice. This history is captured with great authority in Reflections on the Supreme Court of Ghana, written by the distinguished retired Justice Professor Samuel Kofi Dateba, published in 2015. In chapters 10 and 11 of that work, Justice Databa shows how the court's decisions have shaped not only legal doctrine, but the very culture of governance in this country. He makes the point that the courts must continuously extend the boundaries of law within the limits of rationality and good governance. Since 1876, this court has lived through the colonial era, independence in 1957, and the First, Second, Third, and Fourth Republic. The Supreme Court was abolished twice by military government and returned twice. You cannot permanently remove the need for justice in Ghana. I pause here and recognize all 28 Chief Justices who have led this court since 1876, from the days of Sir David Patrick Chalmers, the very first, through to our current Chief Justice, His Lordship Paul Bafuboni, and to each of them we give honor. 3 decisions stand above the rest in defining this court, and these have been mentioned especially in the documentary we watched. In Tufua versus Attorney General 1980 Ghana Law Report 637, the court struck down Parliament's rejection of Chief Justice Apalu as unconstitutional and affirmed that any citizen may invoke the Supreme Court's jurisdiction to defend constitutional order without any personal interest beyond citizenship. In Salah versus Attorney General 1970 GLR 55, the court rejected an interpretation of the 1969 Constitution that would have dismissed hundreds of public servants. In New Patriotic Party versus Attorney General 1993-94 2 GLR 35, it was decided in the very first year of the Fourth Republic that the courts declared that the use of public funds to celebrate the 31st December coup anniversary was unconstitutional. Together, let's read alongside Article 1, 2, 1, 130 of the 1992 Constitution. And these cases confirm that this court is not merely a court of law. It is the guardian of our constitutional order. In Tufua versus Attorney General, the court also gave us words that have never lost their power. Per SOA JSC at pages 647 and 648, the Constitution is a living organism capable of growth and development, as the body politic of Ghana itself is capable of growth and development. A broad and liberal spirit is required for its interpretation. A doctrine approach would not do. To illustrate this principle, the courts reached out for the words of St. Paul in his first epistle to the Corinthians, chapter 12, verses 14 to 20, and reminded us that the body is not one member, but many, and that every part must be given its proper effect. Every single word in the Constitution has an effect. Every part must be given effect. This has remained the instruction of the courts, following in its very best moments. The Supreme Court under the contemporary era, like every living institution, the Supreme Court has had to change with times. And one clear example is the reform of the Supreme Court rules following the 2012 presidential election petition. In Re Presidential Election Petition Akufo-Addo, Bawumia, and Obechebi Lamte versus the Electoral Commission, NNDC, 2013. This lasted for 8 months. The Rules of Court Committee under Article 157 responded with a more efficient procedure for future election petitions. The court has also encouraged alternate dispute resolution to bring dispute resolution closer to the ordinary people, and has remained faithful to the purposive approach to constitutional interpretation that the Tufo case established. However, honesty requires that we speak of the difficult chapters too. On the 30th of June, 1982, 3 High Court judges and a retired army officer were abducted and murdered at the Bundasa military range. Justice Frederick Poku Sarkodie, Justice Cecilia Kranting Addo, Justice Kojo Ajay Ajipong, and Major Samuel Akwa. We honor their memory on Martyrs' Day each year and will do so again today. More recently, we have read the research on public sentiments and trust in the judiciary. I am glad that we are taking steps within the judiciary to address these directly. Article 1:1 of the Constitution reminds us that the law draws its authority from the sovereign will of the people. So when the court listens to the people, it honors its own foundation. The role of the executive arm of government towards the effectiveness of the judiciary over the past 150 years. The great Baron Montesquieu, writing in L'Esprit de Loi in 1748, taught us that liberty depends on keeping the 3 arms of government separate. He also understood that these organs, though independent, are bound by the nature of things to work in concert. Article 127 of the 1992 Constitution guarantees the judiciary's funding from the Consolidated Fund, and the executive arm of government has been consistent in institutional support since 1876. This relationship has grown deeper. It was an executive decision by the PNDC that birthed the 1992 Constitution. The consultations, the drafting by the Committee of Experts, the referendum that gave this Constitution its authority were all initiated under executive authority. When the Constitution needed review, the executive established the Constitutional Review Commission in January 2010, chaired by Professor Albert Fiajo, and they submitted their final report in 2011. Under His Excellency John Dramani Mahama, a new committee continues this reform work, and through all of this, one thing has remained constant. The judiciary has 7 thoughts. 1. The foundational principles of this court, built through its history, its decisions, must continue to guide it for the next 50 and 150 years. To 4, Salah, NPP versus Attorney General are not old cases to put away. They are living instructions about what this court is for. 2, the administration of justice cannot remain untouched by artificial intelligence and digital technology. The Supreme Court must find practical ways to use technology to cut delays in court hearings, in processing cases, and in executing judgments. Slow justice is expensive justice, and expensive justice is justice that only a few can reach. 3, our jurisprudence must neither become rigid or close to developments elsewhere, nor so open that it loses its grounding in Ghanaian values, culture, and experience. We can learn from others without losing ourselves. 4, public legal literacy and access to justice must be real priorities. If ordinary Ghanaians cannot understand what the courts are doing, or do not know what the courts are doing, or cannot afford to use the courts and may not trust the courts, then the most brilliant judgments will not serve their purpose. Outreach, plain simple language, and genuine openness are not extras. They are part of the job of the courts. 5. The court must guard with all its heart and soul its culture of excellence and independence. Institutions are made by people within those institutions. How judges are appointed, the standards they are held to, the example they set for the bar all matter greatly. Ghana's judiciary has produced the fine in its finest moments through people of real character. The next 150 years will be built the same way. For the next 100 years and beyond, our judges must remain in the vanguard for justice and legality, as so powerfully pronounced by one of Ghana's finest legal luminaries, Chachi Chikata, during the lecture yesterday and award ceremony at the UPSA. The court must continue to stand as the final fortress against arbitrariness, abuse of power, and constitutional erosion. 7. The Supreme Court must continuously deepen gender-sensitive inclusiveness and broaden access to justice for all, especially for vulnerable persons, women, persons with disability, and the poor. Justice must not be the preserve of the privileged. The doors of law must remain open at all times for the vulnerable, the unheard, and the underserved. Her Ladyship Chairperson, distinguished ladies and gentlemen, as this noble institution steps into the next century and a half, may it continue to be guided by the sacred symbolism of holding aloft the scales of justice, higher than power, higher than politics, higher than popularity, and to do so without fear or favor, affection or ill will. In the immortal words of Amos 5:24, let justice roll like waters and righteousness like an ever-flowing stream. May that charge continue to animate this honorable court and the judicial system in every season. Once again, on behalf of His Excellency, the President of the Republic of Ghana, we say to the judiciary of Ghana, congratulations, you have earned this celebration. Happy 150th anniversary, and may justice continue to reign in the Republic of Ghana. Thank you.
I thought it would be more resounding. I know we're warming up because we are yet to hit the apogee of this event. But thank you very much to our partner, Dr. Raymond Atuguba, Prof. Raymond Atuguba, yes, the Dean of the Ghana School of Law. So we'll take a performance from Ebibi Goma as a breather, and then we will move to the next phase of this sesquicentennial celebration.
break into a tumultuous applause for Bibi Goma. We must acknowledge the presence of Professor Kofi Abuchi. He is the Dean of UPSA. Prof, you're welcome. Professor Atefua is also here. Ebo Baton, former Deputy Attorney General. And last but not least, Kweku Ansansari is the Director of the Ghana School of Law. Former Director of the Ghana School of Law. Thank you. We've now come to a very important portion of this whole exercise. I call it the pièce de résistance of the exercise. Ladies and gentlemen, we're going to call upon the person at the helm of the judicial service. Ladies and gentlemen, the Chief Justice of the Republic of Ghana, His Lordship, Justice Paul Bafo-Boni.
Please sit down, please sit. Thank you very much. The Honorable Deputy Chief of Staff and representative of the President, Nana Oye Bampoado, the representative of Parliament, the Honorable Deputy Attorney General and Minister for Justice, Dr. Justice Shremsai, distinguished former Chief Justices, Her Ladyship Georgina Theodora Wood, Her Ladyship Sophia Abna Boafoa Akufo, my Lords and Lady Justices of the Supreme Court, present and retired, the Judicial Secretary, Mr. Musa Ahmed, and other Justices of the Superior Courts here in present, the Honorable Aaron Michael Okwei, the Right Honorable Speaker of the Fourth Republic, other special guests of honor, Nime, Name, the members, the Bar President and members of the Bar, our friends from the media, our friends from the security agencies, especially Director General of Prisons, Mrs. Patience Bafo-Boni. She protects me in the house, and now he's here to protect me. So I have to specially acknowledge her. Otherwise, I may not have a place to return to this evening. Members of the clergy present, and may I especially acknowledge Sheikh Arabiyao, representing the National Chief Imam. Ladies and gentlemen, it is refreshing to know that this is one of the rare occasions where we gather as a judicial family with no case files before us, no preliminary objections to determine, and no applications for adjournment. And for once, I believe we may all agree, without the need for concurring opinions or dissent, that this is a good day for the law. It is not often that an institution is given the privilege of pausing to look at itself in the mirror of time. Today is one of such rare moments, a moment not of noise, but of reflection, not of ceremony, but of reckoning. 150 years ago, in 1876, under the Supreme Court ordinance, a quiet but profound chapter began on these shores. The highest court of the Gold Coast was formally established, not in grand ceremony, but with a solemn duty to guard laws, liberties, and the promise of justice for all. Today, we gather here not merely to mark the passage of time, but to reflect deeply on its meaning. For institutions do not become great by years alone. They become great by the courage with which they serve their purpose. And in our case, by the fidelity with which they uphold the calling of justice. Madam Chair, today, we launch the celebration of Supreme Court of Ghana at 150 under the theme, quote, honoring the past, celebrating the present, and defining the future, end quote. This anniversary is more than a milestone. It is a moment for honest reflection, quiet gratitude, and bold hope. 150 years is remarkable, but history will not judge us by how long the court has existed. It will judge us by what we did with the moment entrusted to us, whether we merely celebrated the past or whether we had the courage to define a brighter future. This anniversary, therefore, must be remembered as a commitment to faster justice, to accessible justice, to transparent justice, and to a judiciary worthy of the enduring trust of the Ghanaian people. Let us first honor the past with the respect it richly deserves. From the early courts in Cape Coast, where the foundations of our legal tradition were laid in the very cradle of what will become Ghana, through the colonial era and the turbulent years after independence, men and women of courage sat on the bench. They defended the rule of law, often under pressure, sometimes making difficult choices, yet leaving behind a legacy of integrity that still lights our path. We remember the pioneering judges who built this institution brick by brick, literally and figuratively. We remember the first Ghanaian voices that rose in our courtrooms, helping shape a young nation into a constitutional democracy. Their footprints live on in every judgment that has protected rights, resolved disputes, and upheld the dignity of the ordinary citizen. We are especially honored today by the presence of three distinguished former Chief Justices. Her Ladyship Georgina Wood, our first female Chief Justice, and incidentally the longest serving Chief Justice. From the history of, I'm on record, Georgina Wood served 10 years. The nearest person was Justice Apollo, who served 9 years. Now, Her Ladyship Judge Sofa Abuna Boafo for our chair for today, and His Lordship Justice Kwesi Eniyabua. When I wrote this when I was writing this speech, he had promised to be here. That is why his name appears here. We are also very much honored by the presence of retired justices like Justice Pegan, who, when he was invited, despite the fact that he doesn't feel too well, promised that he will be here, and he is here. My Lord, we are very, very grateful to you. I also want to especially mention the name of Justice Samuel Alan Broby, who actually mentored me, and I'm certain mentored most of the judges who are here. I would also like to mention Justice William Atuguba. When I joined the Supreme Court in 2008, he was one of the pillars that I found difficult to get near to, because he and Sophia Kufu were like institutions. I had been taught in the law school by Justice Datiba, so I felt comfortable in his presence. But these two people, they had been in the Supreme Court for so long, and they were like institutions. But Justice Datiba has a way of making you feel very much welcome. And brother, thank you so much for your presence. Your leadership reminds us that the judiciary is not about one person or one era, but a continuous chain of dedicated service. Thank you for the paths you cleared and the high standards you set. But the adversaries must not only celebrate, they must also speak truth. After 150 years, we must ask ourselves honestly, are we where we should be? Should congestion and delays still burden our courts? Should we still lean so heavily on manual processes in a digital age? Should access to justice in too many cases still hinge on geography, cost, or time? These are not attacks on individuals. They are questions about systems. Because the truth is this: longevity without renewal is a quiet form of decline. And the law, if it is to remain relevant, must not only endure, it must respond. That is why this anniversary is not only a commemoration, it is a turning point and a mandate. The court of today is a living institution, busier, more accessible, and more transparent than ever. We have embraced technology, strengthened processes, and worked tirelessly to deliver justice that is timely and fair. Our courts, from the apex to the districts, serve millions who turn to us when all else feels uncertain. We celebrate the present through concrete actions already in motion. Through the e-justice program, we are moving toward digital filing, digital service, virtual hearings, and digitized records, making justice faster, more efficient, and more accessible. We have introduced extended court sittings via the two-stream system, turning time itself into an ally of justice. Through specialized courts for emerging areas of law, we are acknowledging that the law must grow with society. And through the ongoing revision of our court rules of court, we are attempting something fundamental to ensure that procedure serves justice and does not suffocate it. We are equally strengthening security and infrastructure around the courts, ensuring that justice is delivered in safe and dignified environments. And we are actively and cautiously reforming legal education to achieve a twin solution of expanding access while preserving quality. These are not distant dreams. They are deliberate steps that are already underway. And if we are to be honest, and on a day like this we must be, we cannot say that all is well. There are still delays. There are still barriers. There are still moments when justice feels distance to those who need it most, and confidence is shaken when justice comes too late, or costs too much, or feels too far. The next chapter of our court must not be rhetoric. It must not be reform for its own sake. It must be a deep commitment to excellence in the delivery of justice for all. The future of this court must be faster, because delayed justice is diluted justice. Clearer, because obscure justice is inaccessible justice. Closer to the people, because distant justice is denied justice. In the coming weeks and months, the planning committee's rich program will bring the vision of this anniversary celebration to life. Public lectures that take the conversation on justice to the people, a powerful documentary capturing our journey from Cape Coast to the present, a commemorative compendium preserving our institutional memory, legal aid outreach to underserved communities, and meaningful legacy projects that will outlast this moment. These are opportunities for every Ghanaian, young and old, lawyer and layperson, to reconnect with the judiciary and help shape its next chapter. Ladies and gentlemen, the judiciary does not stand apart from Ghana. We are woven into her history, her struggles, her progress, and her highest aspirations. When the Supreme Court is strong and independent, the rule of law stands firm. When justice is accessible, impartial, and humane, democracy breathes freely. Behind every case is a human story, a family, a livelihood, a life in the balance. Courts are human institutions, only as strong as the integrity of those who serve in them, only as trusted as the fairness they demonstrate, and only as relevant as the justice they deliver. No technology or reform can replace conscience and judgment. Madam Chair, distinguished ladies and gentlemen, my lords and ladyships, as we unveil the theme, the logo, the anniversary cloth, and other symbols of this milestone, let us do so with pride, but also with a solemn promise, a promise that the next 150 years will witness a court that is even more just, more efficient, more trusted, and more deeply reflective of the best values of our nation. And as I've often said, my own tenure is but a brief blip, a relay in a long race. What we build must be a system of continuity, where each generation carries the baton forward with greater purpose. To the hard-working planning committee, ably led by my brother, His Lordship Richard Ajay Frimpong, and to all members of the subcommittees, staff and partners who have labored tirelessly in a short time to make this to fruition, thank you. Your dedication has made this launch possible. To our traditional leaders, especially the Gbesemanje, and all invited guests, your presence honors us and reminds everyone that justice has deep cultural roots in Ghanaian society. Excellencies, my lords, ladies and gentlemen, May I invite you to join me in launching the Supreme Court of Ghana at 150. May the Supreme Court of Ghana rise to even greater heights, not as a relic of history, but as a living, breathing instrument of justice for all. May God bless the Supreme Court of Ghana. May God bless our beloved homeland, Ghana.
So we are on GBC, GTV, we are on Joy News, we are streaming live on GH1 and Star FM.
And for those who have supported us in this endeavor, we have the French Embassy. The French Embassy, if there's any person here, French Embassy, the U.S. Embassy, the Danish Embassy, and the Canadian Embassy.
Well, as you well know, we will require a lot of money to celebrate this and to ensure that the Supreme Court and the judiciary remains resolute in dispensing justice in our land. And we are privileged and excited to have these financial institutions as partners in this endeavor. We have the Ghana Commercial Bank. If the reps are here, the CEOs or MDs are here, they should kindly give us a wave as we acknowledge them. The Ghana Commercial Bank, ADB, CBG, Consolidated Bank Ghana, the NIB, SNITS, GNPC, NPA, NPC, Ghana Gas, and GAPOHA.
And in supporting us further, we have our development partners, United Nations Children's Fund, German Technical Cooperation, UNHCR, US Embassy, the French Embassy, the Danish Embassy, the Canadian Embassy, the Australian High Commission, World Bank, United Nations Population Fund, United Nations Office for Drugs and Crime, Ghana Integrity Initiative, British FCDO, and last but not least, International Justice Mission.
Well, Dr. Doris Aglobiche is here representing the United Nations Population Fund. Kindly give us a wave. Thank you very much for joining us. Ladies and gentlemen, we will take a spot of music from the choir, the Judicial Service Choir.
Thank you very much. The Judicial Service Choir. We have now reached a very important portion of this exercise. We're dealing with this man, a retired justice of the Supreme Court. He retired on 1st August 2021, and he was on the bench for a whopping 30 years. This man is so brilliantly well-versed on all segments of the law. No wonder we had to invite him to deliver this sovereign message. Put your hands together for the guest speaker of this occasion, Mr. Justice Yao Apau.
Madam Chair, Her Ladyship, Justice Sophia Abnahabuafua Akufu, the Honorable Chief Justice and Justices of the Supreme Court, the Honorable Chief of Staff, I heard the name Honorable Julius Debra, and honorable representatives of government herein present. The sitting Speaker of Parliament, I also heard his name mentioned. My own classmate, Alban, and the retired Right Honorable Speakers, Honorable Aaron Kwe and Do Ajaho. Distinguished members of the bench and the bar, members of the Council of State herein present, heads of public institutions herein present, the clergy, including the representatives of the Chief Imam, esteemed colleagues, the retired members of the Superior Court of Ghana, Nime, Name, invited guests, security agencies, the fourth estate of the realm, ladies and gentlemen. It is both a profound honor and a solemn privilege to address this distinguished gathering on the occasion of the sesquicentennial anniversary of Ghana's Supreme Court. I extend my deepest respect to the Chief Justice and the Honorable Justices of the Supreme Court, whose stewardship continues to uphold the dignity, integrity, and authority of this noble institution. I also respectfully acknowledge the presence of the Chief of Staff and representatives of government and members of the legislature led by their leaders, majority and minority, whose commitment to constitutional governance reinforces the foundational principles upon which our republic stands. I further recognize the invaluable contributions of members of the bench and the bar, whose collective efforts sustain the administration of justice and enrich the development of our legal system. To our distinguished guests and partners in justice, your presence here today reflects a shared commitment to the rule of law and the enduring ideals of fairness and accountability. This occasion marks not merely the passage of time, but a significant milestone in the history of justice in Ghana. 150 years of the Supreme Court represents a legacy of continuity, resilience, and institutional evolution. It is a testament to the enduring strength of the rule of law, the preservation of constitutional order, and the unwavering pursuit of justice across generations. Between these years, the country has experienced the stewardship of 28 Chief Justices, as you have already heard, from Chalmers in 1876 to Bafuboni in 2026. Out of this number, 12 were colonial judges and the remaining 16 Ghanaian, 3 being female, one of the females being the first female Chief Justice in Ghana and Africa. You've heard it. Now, the 16 Ghanaians was first led by Sir Akukosa, who was the first Ghanaian Chief Justice and the 13th on the list from 1956 to 1963. The Supreme Court is the apex court in Ghana's hierarchy, of course. The eminent professor of law, emeritus, and renowned jurist, Samuel Kofi Dateba, described the Supreme Court as a fascinating court in his book, Reflections on the Supreme Court of Ghana. Why the description, fascinating court? According to the learned professor, author, and jurist, our Supreme Court, when compared to other Supreme Courts in other jurisdictions, has no equal when it comes to the variety of jurisdictions it exercises and the automaticity of access to it in majority of cases. Maybe the only exception in terms of multiplicity of jurisdictions and ease of access to the court is the Supreme Court of India, which MP Jain in his book, Indian Constitutional Law, 5th edition, described as the most powerful apex court in the world. Our Supreme Court's several types of jurisdiction include original jurisdiction in all matters relating to the enforcement or interpretation of the Constitution as provided under Article 130 of the Constitution, appellate jurisdiction, both criminal and civil, including appeals from treason trials, and the judicial committees of the National House of Chiefs, the review jurisdiction, supervisory jurisdiction, jurisdiction over presidential election petitions, etc. Aside of its several or varied jurisdiction, our Supreme Court has the general authority to develop Ghanaian case law by exercising its freedom to depart from its own previous decisions when it appears to it right to do so. According to statistics obtained from the registry of the Supreme Court, between the years 2020 and 2025, inclusive 2025, the total number of cases filed and registered for hearing before the Supreme Court were 2,212. These were made up of writs invoking the original jurisdiction of the court, which were 138 criminal appeals, 41 civil appeals, 443 prerogative writs, 536 review application, 118 referrals from other courts, 6 and other motions, 1,052. In 2025 alone, cases filed before the court for hearing were 31 writs, 4 criminal appeals, 451 civil appeals, 102 prerogative writs, 18 review applications, and 2 referrals, then 198 other applications or motions. How did the court come this far? How long and rough has been this journey? How did the Superior Court emerge in the Gold Coast, now Ghana? What relationship did it have with the pre-existing indigenous systems of governance and adjudication? How did legal professionalism develop around it, and what has the court come to represent in the constitutional life of the Ghanaian state? The question is, how many people know that the Supreme Court is the oldest surviving institution of public authority in Ghana? The Supreme Court predates independence by more than 80 years and has endured through colonial rule, late imperial reform, independence, republican experimentation, intermittent military interruptions, and democratic restoration. The history of the Supreme Court is not therefore a mere history of a court, but part of a longer history of how authority, legality, and constitutional order have been organized in this country. The Supreme Court Ordinance of 1876, number 4 of 1876, formalized a colonial legal system based on English common law. Equitable doctrines and statutes of general application in force as at July 24, 1874. It acted as the foundation for the modern Ghanaian judicial system, enabling the legal profession and formally separating the judiciary. It is significant to note that the Supreme Court did not arrive in the Gold Coast in a vacuum. It came to meet local institutions or neighbors already playing political and judicial roles. Dispute resolution and public accountability. Chiefs, elders, lineage heads, and authorities, Asafu groups, and community leaders exercised jurisdiction long before the arrival of the colonial courts. The governance system was part of a functioning political order with its own principles of legitimacy, sanction, and social regulation. The received colonial law or regime therefore did not introduce legality into an otherwise unregulated social field. It superimposed a new legal authority or hierarchy upon existing structures of governance, thus establishing a dual legal system. On one side stood the superior courts governed by English law, English procedure, and colonial legal doctrine. On the other side stood native tribunals and customary fora, where indigenous law continued to function under colonial regulation. The establishment of the Supreme Court also contributed to the gradual regularization of legal practice. It created clearer procedures of admission and helped stabilize the institutional environment within which a recognizable legal profession could develop. One of the great landmarks in this history was the rise of John Mensah Saba of Adamabu as the first native Gold Coast professionally qualified to practice law before the Supreme Court. Through both advocacy and scholarship, Saba mounted a formidable defense of African customary institutions against simplifications and encroachments of colonial jurisprudence. He was followed by figures of equal significance including Kofi Asam, Charles James Bannerman, Thomas Hutton Mills, J.E. Kesley Hayford, Akufo-Addo, father not son, J.B. Dankwa, etc. These were not merely practitioners of the law in the narrow sense. They were members of an emergent African intelligentsia for whom law provided both a professional vocation and a conceptual vocabulary through which both professional vocation, and an African conceptual vocabulary through which to think about sovereignty, rights, custom, authority, and public order. I think my glasses is giving me problems. I can't see well. Good. Independence in 1957 transformed the constitutional position of the Supreme Court. the Supreme Court ceased to be merely an institution of imperial administration and became the apex court or judicial organ of sovereign Ghana, with a Ghanaian as a Chief Justice. This was more than a change of constitutional symbolism. From 1960, when Ghana first became a republic, and having passed through 3 other republican constitutions, 1969, 1979, and now 1992, the Supreme Court has assumed the functions associated with a modern constitutional tribunal. It is required to interpret constitutional texts, adjudicate politically sensitive disputes, delimit executive and legislative power, and pronounce upon the legal rights and status of citizens and institutions. Today, we gather not only to commemorate this remarkable journey, but also to reflect on its meaning and to reaffirm our collective responsibility to sustain and strengthen this vital institution for the future. This address is intended to serve 3 interrelated purposes. First, it offers a moment of reflection, inviting us to look back with clarity and gratitude at the journey of the Supreme Court over the past 150 years. Second, it is an occasion for celebration, recognizing the enduring contributions of the court to the development of Ghana's legal system and democratic governance. Third, and perhaps most importantly, it is an opportunity for forward thinking, to consider how this esteemed institution can continue to evolve in response to the demands of a changing society while remaining anchored in the principles of justice and the rule of law. The Supreme Court occupies a central and indispensable place in Ghana's democratic architecture. As the final arbiter of justice and the ultimate interpreter of the Constitution, it serves as the guardian of the rule of law and the protector of fundamental rights and freedoms. Its decisions shape the contours of governance, define the limits of power, and provide the framework within which public institutions operate. In moments of national uncertainty or contestation, the court stands as a stabilizing force, offering lawful and peaceful resolution grounded in constitutional principles. In reflecting on this important milestone, it is useful to frame our discourse around 3 interrelated pillars: the past, the present, and the future. The past calls us to honor the legacy of those who built and sustained the institution through periods of transformation and challenge. The present invites us to recognize and celebrate the achievements, strengths, and relevance of the court in contemporary Ghana. The future challenges us to think critically and constructively about the role of the Supreme Court in an evolving legal and societal landscape, and to define the path that will ensure its continued credibility, independence, and effectiveness for generations to come. In reflecting on the past, we are reminded that the story of Ghana's Supreme Court is deeply intertwined with the broader evolution of the nation's legal and political history. From its origins within the colonial judicial system, through the transition to independence, and into the era of constitutional democracy, the court has undergone significant transformation while maintaining its central role as an arbiter of justice. Each phase of this journey has contributed to shaping an institution that reflects both historical continuity and progressive development in the administration of law. The contributions of past judges stand as a testament to the intellectual depth, integrity, and courage that have defined the court over the decades. Through their decisions, they have developed and enriched Ghanaian jurisprudence, laying down legal principles that continue to guide contemporary judicial reasoning. More importantly, in moments of national difficulty and uncertainty, they upheld the rule of law with firmness and independence, ensuring that justice prevailed even when circumstances were challenging. Their work not only resolved disputes, but also reinforced the authority of the Constitution and the sanctity of legal order. The resilience of the Supreme Court as an institution is particularly noteworthy. It has navigated periods of political transition, constitutional change, and national uncertainty, often serving as a stabilizing force within the governance framework. Despite these challenges, the court has remained committed to its mandate, adapting to changing legal and societal contexts while preserving its core values. This resilience has been critical in sustaining public confidence and maintaining the continuity of justice across generations. The legacy of this rich history is evident in the strong foundations of constitutional governance and the well-established legal doctrines that underpin Ghana's judicial system today. The traditions of fairness, independence, and respect for due process that were cultivated over time continue to define the character of the court. As we honor the past, we do so not only in recognition of what has been achieved, but also with an appreciation of the enduring principles that must guide the court into the future. In celebrating the present, we acknowledge a Supreme Court that continues to stand at the very heart of Ghana's constitutional democracy. Today, the court performs its role as the guardian of the Constitution with clarity and authority, ensuring that all actions of the state are subject to the supreme law of the land. As the final arbiter of justice, it provides definitive interpretation of legal and constitutional questions, thereby shaping governance, protecting rights, and maintaining the delicate balance among the arms of government. I want to give an example. During the election time, when this birth certificate issue arose, the matter went to the Supreme Court, and the Supreme Court determined that the mere possession of a Ghanaian certificate does not make one a Ghanaian. There was hula baloo in the country. The Supreme Court says even if you have birth certificate, you are not a Ghanaian. But it's not the Supreme Court which is saying it. It is the Constitution who says this. You can have a Ghanaian birth certificate, but if your parents or one of them is not a Ghanaian, you are not a Ghanaian. You only hold the certificate. If your certificate has your parents as General Olusegun Obasanjo and Mrs. Obasanjo, how do you become a Ghanaian? That is the law. And the Supreme Court was firm on this. The achievements of the court in recent years are both significant and commendable. It has demonstrated its capacity to handle complex constitutional and electoral disputes with professionalism and composure, providing lawful avenues for the resolution of highly sensitive national issues. Now, in 2012, Ghana experienced its first electoral election petition. It was a novelty. It had never happened before. It took the country by surprise. Now, it took us 8 good months to complete the trial. Wasted a lot of time. It taught the Supreme Court a lesson, which made the court to refine its procedural rules for election petitions. Now, a lot of acrimonies, allegations, insults were made against the court. Judges were insulted. 2012. I remember my senior brother Tuguba. Somebody was insulted. They have taken money, $1 million each. They said all these things. And it will surprise you to note that it was in 2012 that many Ghanaians got to know that there was a court called Supreme Court. They didn't know. And it was there they know the power of the Supreme Court. When my brother, the late Sir John, may his soul rest in peace, was brought into the dock and grilled by Justice Tuguba, people said, hey, we didn't know that there's a court like this that can humble Sir John. Now, all these things happened in 2012. 2020, another petition came, the same hula baloo and insults happened. I remember I was listening to a radio program with panelists from the parties, MPP, NDC, social commentators, and then the panel from the MPP said, he told the moderator, I pity these judges. They were then discussing the allegations of corruption. I pity these judges. Then he says, why? He said in 2012, what these NDC people are doing now, in 2012, we also did it. I also said similar things about bribery. Meanwhile, I had no facts. Now people are saying the judges have taken $2 million, $1 million. Fortunately, I was one of the judges, but I didn't receive anything anyway. So he said, I pity these judges, because all these things we are saying, we have no facts, but we are saying them for political reasons. Then you see the work of a judge. Now, notwithstanding all these acrimonies, the court stood firm. In doing so, the court has reinforced democratic stability and contributed to the peaceful management of political contestation. Its role in strengthening the rule of law and promoting constitutionalism remains central to Ghana's reputation as a stable and democratic state. Equally important is the high level of professionalism and independence that characterizes the present bench. The integrity of the justices, their commitment to impartiality, and the depth of legal reasoning evident in their decisions have enhanced the credibility of the court. There has also been a notable growth in legal scholarship and judicial competence, reflecting both the evolution of legal education and the increasing complexity of cases brought before the court. The present period has also witnessed important improvements in judicial administration. Ongoing reforms aimed at enhancing efficiency, transparency, and access to justice has strengthened the overall performance of the court. The gradual integration of technology into judicial processes, including case management and record keeping, has contributed to improving the speed and reliability of judicial proceedings. These developments signal a judiciary that is responsive to modern demands while remaining grounded in its core principles. Ultimately, the strength of the Supreme Court today is measured not only by its institutional capacity, but also by the public trust it commands. Legitimacy and credibility are indispensable to the effective functioning of the court. The confidence of citizens in the fairness, independence, and integrity of judicial processes is essential to sustaining the rule of law. As we celebrate the present, we recognize that this trust is both a valuable asset and a solemn responsibility that must be continuously nurtured and protected. As we turn our gaze to the future, we are confronted with a rapidly evolving legal and societal landscape that presents both challenges and opportunities for the Supreme Court. The increasing influence of technology, the forces of globalization, and the growing complexity of legal disputes require a judiciary that is not only grounded in tradition, but also responsive, adaptive, and forward-looking. Issues such as digital governance, cross-border transactions, environmental sustainability, and emerging rights frameworks will demand deeper judicial engagement and more innovative approaches to legal interpretation and reasoning. Note the LGBTQ++ issue. In this context, one of the foremost strategic priorities must be judicial innovation. The future of the court will depend in part on its ability to harness technology to enhance efficiency, transparency, and accessibility. The development of digital courts and e-justice systems offers significant potential to streamline case management, reduce delays, and expand access to justice, particularly for citizens who may otherwise face barriers in engaging with the legal system. Embracing these innovations must, however, be done with careful attention to fairness, security, and due process. Equally important is the need for jurisprudential leadership in emerging areas of law. The court will increasingly be called upon to interpret and shape legal principles in domains such as environmental governance, maritime law, digital rights, and economic regulation. In doing so, it must draw on both domestic constitutional values and evolving international legal standards, ensuring that Ghana's jurisprudence remains relevant, progressive, and responsive to contemporary realities. At the same time, the independence of the judiciary must remain sacrosanct. Judicial autonomy is the bedrock upon which the legitimacy of the court rests, and it must be protected from all forms of undue influence. This requires not only constitutional safeguards, but also a sustained commitment to ethical conduct, accountability, and institutional integrity within the judiciary itself. Another critical priority is the expansion of access to justice. The court must continue to promote inclusiveness and efficiency, ensuring that justice is not only available, but also accessible to all segments of society. This involves addressing barriers related to cost, distance, and procedural complexity, and strengthening mechanisms that bring justice closer to the people. Closely linked to this is the imperative of maintaining and enhancing public confidence. Transparency in judicial processes, clarity in communication, and openness in institutional operations are essential in reinforcing trust in the court. In an era of heightened public scrutiny, the judiciary must actively engage with the public while preserving its independence and impartiality. Finally, the future of the Supreme Court depends on sustained investment in capacity building. The development of the next generation of judges and legal practitioners is critical to the long-term strength of the institution. Continuous training, membership, and mentorship and exposure to emerging areas of law will ensure that the judiciary remains competent, resilient, and prepared to meet future challenges. In defining the future, therefore, the task before us is clear: to build on the strong foundations of the past and present, while embracing innovation, strengthening institutions, and upholding the enduring principles of justice, independence, and the rule of law. In reflecting on institutional responsibility, it is imperative to recognize the central role of the judiciary in sustaining democratic governance. The judiciary serves not merely as an interpreter of the law, but as a guardian of the constitutional order, ensuring that power is exercised within legally defined limits. In a democratic state, the courts provide a critical check on the actions of the executive and legislative branches, safeguarding the rights and freedoms of citizens, and reinforcing the principle that no individual or institution is above the law. The strength of a democracy is in many respects measured by the independence, integrity, and effectiveness of its judiciary. At the same time, the judiciary operates within a broader societal context and must continually navigate the delicate balance between the strict application of legal principles and the evolving realities of society. While the court must remain faithful to the Constitution and the rule of law, it must also be attuned to the social, economic, and cultural dimensions of the issues brought before it. This balance does not imply compromise of legal standards, but rather a thoughtful and context-sensitive interpretation of the law that ensures justice is both principled and relevant. In this way, the judiciary contributes not only to legal certainty, but also to social cohesion and national development. Central to this institutional responsibility is the ethical duty of judges. The authority of the judiciary ultimately rests on public confidence, and that confidence is sustained by the integrity, impartiality, and accountability of those who serve on the bench. It is said that justice depends more not on the type of law passed, but on the quality of the judge who interprets or applies that law. Judges are called upon to exercise their functions with independence of mind, free from personal interest, external pressure, or partisan influence. They must demonstrate fairness in their conduct, diligence in their work, and humility in the exercise of power. Ethical responsibility is not an abstract ideal. It is a daily commitment that defines the character of the judiciary and ensures that justice is administered with credibility and respect. In sum, the institutional responsibility of the judiciary is both profound and enduring. It requires a steadfast commitment to democratic principles, a careful balance between law and societal realities, and an unwavering adherence to ethical standards. These responsibilities are not optional. They are the very foundation upon which the legitimacy and effectiveness of the judiciary depend. Conclusion. As we draw this reflection to a close, we are reminded that the legacy of Ghana's Supreme Court is not merely a record of years, but a living testament of the enduring power of justice, constitutionalism, and the rule of law. For 150 years, 31st March 1876 to 30th March 2026, this court has stood as a guardian of order in moments of uncertainty, a voice of reason in times of contestation, and a sanctuary of justice for the ordinary citizen. As the eminent jurist Lord Denning once observed, and I quote, "Justice is rooted in confidence, and confidence is destroyed when right-minded people go away thinking the judge was biased," unquote. That confidence, painstakingly built over generations, remains the most valuable asset of this institution. This occasion, therefore, is not only a celebration, it is also a call to duty, a call to preserve the sacred values that define the judiciary: justice without fear or favor, integrity without compromise, and independence without exception. Alexander Hamilton also reminded us that, and I quote, "The judiciary has no influence over either the sword or the purse. It may truly be said to have neither force nor will, but merely judgment," unquote. And yet, it is precisely that judgment, impartial and principled, that sustains the very fabric of our democracy. As I said earlier, notwithstanding the hula balloons in 2012 and 2020, Ghana did not burn. The people accepted the judgment, which was neither a sword nor a purse. We must therefore ask ourselves, what shall history say of us? That we inherited a strong institution and preserved it? Or that we allowed its foundations to weaken under the pressures of time and circumstance? The answer lies in our collective resolve. The past has given us a legacy. The present has entrusted us with responsibility. The future demands our vision. As we honor the past, we remember those who stood firm when it was difficult to do so. As we celebrate the present, we recognize a court that continues to uphold the Constitution with courage and clarity. And as we define the future, we must commit to building a judiciary that is not only respected, but also responsive, not only authoritative, but also accessible, not only independent, but also trusted. Let us therefore move forward with purpose and conviction. Let us strengthen what has been built, refine what must be improved, and boldly embrace what lies ahead. For in the words of Martin Luther King Jr., I quote, "The arc of the moral universe is long, but it bends towards justice," unquote. It is our solemn duty to ensure that this court remains one of the instruments through which the arc continues to bend in the right direction. That's justice. May the Supreme Court of Ghana continue to stand as a beacon of justice, a guardian of the Constitution, and a symbol of hope for all who seek fairness under the law. I wish all of us happy 150th anniversary celebration. Thanks for your audience.
Please, let's resume our seats as the choir gives us a song.
Let's heartily rejoice, rejoice in the strength of our salvation. Oh, let us sing unto the Lord. Oh, let us sing unto the Lord. Let us sing a joyful noise, and show ourselves that we live in song. For the Lord is our great God, and the King of all God, and the King of the hosts, and the King of the hosts, and the King of the hosts, and the King. Let us go before us again, and show ourselves that we live inside. The sounds of the salvation, and the strength of the music is awesome. This is our living song. Prepare and die. Let us sing. Let us sing. Let us sing. Let us sing. For the Lord is a great Lord. Let us
Thank you very much, Judicial Service Choir. We are gradually cruising to a crescendo. This program would be ending shortly, but not before we hear from the special guest of honor. Our special guest of honor was born to Mr. E.G.N. Okwe, a cocoa merchant, and Mrs. Felicia Awusiki Okwe of Odumase Krobo. He grew up in Asamankese in the Eastern region. and he pursued his higher education at the University of Ghana, the University of London, and Lincoln's Inn, earning a Bachelor of Arts degree in Political Science, an LLB, a Bachelor of Laws, and later a PhD. He is a distinguished lawyer, academic, politician, civil society activist, and a minister of the gospel. He is also a barrister of the Supreme Court of England and Wales, and a senior member of the Ghana Bar. As an academic, he won the prestigious International Rockefeller Senior Scholar Award and the Senior Fulbright. On the diplomatic front, our special guest served as Ghana's High Commissioner to India from 2002 to 2004. In politics, he held ministerial roles as Minister of Energy and Minister of Communication. He has been deeply involved in championing the rights of the marginalized in our society. And he is the sixth Speaker of the Parliament of the Republic of Ghana. Ladies and gentlemen, distinguished persons here present, our special guests of honor for this sesquicentennial celebration, Professor Mike Okwei.
Thank you very much, young lady. There has been a long introduction, and I have 5 minutes to speak. Our chairperson, your ladyship, Justice Sophia Akuffo JSC, retired Chief Justice of the Republic, my Lord Chief Justice of the Republic, our guest speaker, Justice Apao JSC, retired. May I please stand on the protocols established this morning as part of my 5 minutes. I am really honored to be invited to participate in this exceptionally auspicious event. This is a critical celebration indeed. The law, as I have always believed, is the quintessence of the civilized society. The inevitability of the law as regulator of human behavior is underscored by the fact that God himself installed the law in the Garden of Eden by making rules for Adam and Eve. And when they broke the law, God himself became the first judge of humankind. In the process, the omniscient God established the odi alteram partem rule by giving the offenders a hearing, even though God knew all that had already happened. In my practice, I observed one phenomenon. The best judges are the most patient. They listen, they accommodate, they give opportunity to others, and they adjudicate with the wisdom of Solomon. My Lord judges, there is no profession higher than yours, and I say that with all sincerity. And why? God himself is the ultimate judge of all of us. You stand in God's stead on earth, and you need to be careful in this most honorable profession. This is the reason why judges must stand above corruption, as indeed many of our reputable judges have done over the years, and lawyers know who they are. And that is why we continue to doff our hats to Chief Justice Georgina Wood, retired, and others who dealt squarely with the cankerous opprobrium after the Anas inquiry had caught some judges in the corruption web. The law should always be supreme in a civilized society. I had the favorite statement I've always made: your wife even is your wife because the law says so. If it were not so, then when you take a stroll with her, a macho man will come from nowhere and he will take possession. But the law will defend you, and that is the essence of law. The law's delay and the feeling of the ordinary person that legal administration is veiled in allegories should be a matter of deep concern at a time like this. I have advocated several years a system in India which allows morning judges and afternoon judges who use the same court, and justice is accelerated. It is very, very much worthy of emulation. Let this be done as soon as it is possible. It is useful to recount that when I was a schoolboy, we read about expeditious adjudication of cases in the Daily Graphic, way far away in Asamankesi, and the good work being done by magistrates and judges, one of the principal figures of which was Lady Justice Annie Baita, who later became Mrs. Justice Annie Giagi. The people felt that law was being exercised and applied. A strong public relations department is needed in the judiciary. After all, a cornerstone of our constitution is that justice belongs to the people and it emanates from them. Very often, the criticisms come out of ignorance. And how will the ignorant know? The judiciary must take justice to them through modern communication. Our courts have been through several trajectories, including challenges from public tribunals under the PND's revolutionary years. It will interest you to know that it was only on insistence of Chairman Rawlings that the tribunals appeared in the 1992 Constitution at all. I am reliably informed that through persuasion by Justice D.F. Annan, a compromise was reached that the tribunals will be in the Constitution, but they will not be applied in any way. Notably, President Rawlings honored his pledge, for which matter I will say, let not the tribunals come back as alternatives to the regular courts. The English jurisprudence jealously guards the concept of the ordinary courts of the land. The ordinary courts of the land, as against what we all knew as the dangerous systems, including the Star Chamber of the European times. Distinguished ladies and gentlemen, the courts have suffered considerable banter in the past. The cases that we all have heard this morning and we all know so well have brought a lot of difficulties, which include Ray Akoto, Agukosa in the Tawia Adamafiu and others case, and so on and so forth. One thing that we need to do by all means is we must all come to acknowledge that the Supreme Court is the final arbiter of all controversies in the Republic of Ghana. No aspect or part of government, no matter what, is so supreme that it cannot adhere to the Supreme Court of Ghana. The Parliament of Ghana is not sovereign like we learnt about the Parliament of England. It has limitations well drawn out by the law, which we have all agreed to regulate us, and that is the 1992 Constitution. An Act of Parliament, insofar as it offends any part of the Constitution, can be struck out as unconstitutional by law, provided, and we must all adhere to it. It is painful particularly to recount that we want to be selective about our acceptance of the rulings of the Supreme Court. I believe with all my heart this must stop. We accept judgments because they have been duly made by the highest court of the land. On the whole, we should salute the Supreme Court for going through all manner of trajectories, whether by even death. We have had judges who have stood by the processes of the law. We pray that the law reform must continue seriously as an aspect of the application of law in this country. Many people criticize the law because sometimes you are not able to fill the lacunae in the law. And I recommend that the judiciary must work more hand in hand and in tandem with Parliament to fill some of the areas of the law which require serious attention, including alternative sentencing and all the areas we know. The Supreme Court has done very well. It continues to apply the law, and I trust it will become the adjudicatory aspect of our system and in all controversies. Long live the Supreme Court, long live justice in Ghana. Thank you.
Distinguished ladies and gentlemen, we are at a very important part of this ceremony where we will unveil, we'll have the logo for the sesquicentennial celebration unveiled.
And to do the unveiling, I have the pleasure of inviting the following distinguished personalities. Ladies and gentlemen, we would invite Her Ladyship Justice Sophia Akufo, a former Chief Justice. His Lordship Justice Paul Bafo-Boni, the sitting Chief Justice. The Right Honorable Professor Mike Okwei, former Speaker of Parliament. Justice Georgina Wood, former Chief Justice. And finally, His Lordship Justice Richard J. Frimpong, Justice of the Supreme Court.
So as they get ready for the unveiling, permit me to acknowledge the presence of a former Deputy Attorney General, Joseph Bemka, also the President of the Ghana Journalists Association, Mr. Albert Kwabnajum, Mr. Emmanuel Akwete, the Executive Director of IDEG, and Ms. Hilda Mensah of UNICEF. Thank you very much for being part of this.
Where Justice is if
So we're about to witness the logo, which will signal the celebration of 150 years of existence of the Supreme Court of Ghana. So there you have it, the logo for this sesquicentennial celebration of the Supreme Court. And we will now call on the chairman of the Anniversary Planning Committee, His Lordship Justice Ajay Frimpong, to tell us how they arrived at this logo and what it symbolizes.
No, it's very short. No, let them see. Let them see. After taking a break, then they will shoot. Good job. Can I go on? Respectfully, Your Ladyship the Chair, may I kindly be permitted to proceed on the existing protocol as I perform this short but very solemn duty. The logo we just unveiled is no doubt a magnificent one.
But that was not the only quality the committee looked for in a logo. Beyond its high level of splendor, we were interested in an emblem that speaks to the belief and core values of the court we are celebrating today, the Supreme Court of Ghana. And so you would see blue and white skies above the roof of the fortress. They represent the recognition of divine authority of the Supreme Court over all of the Supreme God over the court and the justices who sit in it. And they speak to their deference to God's own divine wisdom in their decision making as they dispense justice to the people of Ghana. Further, you would find 2 green trees at the extreme horizontal end. They signify the law as a living concept, capable of growth and renewal to meet the aspirations of the people of Ghana. The people of Ghana are artificially captured in their nationhood, which is signified by the 2 flags of the Republic on the sides. The fortress and their giant pillars represent the strength and resilience of the court against external pressures, and their whiteness represent purity and sacredness of justice. The scale of justice, of course, is the ancient symbolic representation of fairness and impartial judgment. Finally, the dominant blue color, which is the conventional color of the judiciary of Ghana, signifies calmness, trust, and peace, and it speaks to the court's contribution to the governance, the peace, and stability of the country. These features encapsulate the virtues upon which the court has thrived for the last century and a half, and shall continue to be its guiding core values as it treks into the future. On this note, I say ayiko to the Supreme Court, your Supreme Court, my Supreme Court, and our Supreme Court. Thank you very much.
Thank you very much, my Lord. We have now arrived at this item, the issue of fundraising. Before we do that, I think that the speeches which have been delivered here this morning are great. They are super califragilistic. And I think that the Council for Law Reporting must endeavor to have them compiled and edited in a special edition of the Ghana Review of Ghana Law. All the speeches, in particular, the speech delivered by the sovereign speech delivered by the guest speaker for this occasion. Ladies and gentlemen, it is now time for us to see how we can raise money. The pursuit of this endeavor has been made with money. And I think that the president of the Ghana Bar Association is a person who is properly and accurately endowed to do this particular arrangement. Ladies and gentlemen, put 2 hands together and welcome the one and only First Lady President of the Ghana Bar Association, Mrs. Efua Garte.
Thank you very much. It has been an interesting morning, and we are now in the afternoon. And so I know from all that we have heard and from what we have seen on the program, we know what our duty is. We are here to honor the past. Honor the past by making sure that when we talk about a defining future, we have clear projects that we have embarked upon to show that indeed we have arrived. 150 years is a long time, you will agree with me. And therefore, when the planning committee met, we realized that we couldn't come out with just one project. Just one project will not befit 150 years. So we have 2 projects. And we trust that you would have a quick look at some of the things that we are talking about. This is the Cape Coast. This is the Cape Coast High Court. And we have been treated to a lot of information this morning and this afternoon about when our court system started. Cape Coast was the capital of the Gold Coast in 1877. And a century later, this edifice was built. But members, look at the state of the edifice. We think that it is about time we ensured that we have a befitting court complex with an ICT hub attached. And therefore, this is what we are looking at. Buildings that will make you proud. Buildings that will make you feel that justice is going to be dispensed. And when I say 2 projects, I have shown you what is in Cape Coast. But I cannot show you what is in Tema because it doesn't exist. There's no court complex in our port city, Tema. And so what we are going to do here this afternoon is that there are some beautiful ladies going around. And I think that for all the corporate entities, one thing that should be on your corporate social responsibility list is to help us to fund this multi-million-dollar project. 2 court complexes attached with an ICT hub, because we are talking about going into the future. And who wouldn't want to go into those beautiful buildings that we saw? And who wouldn't want to practice there? And who wouldn't want to be a judge in a place such as this? So ladies, without much ado, please, if you raise your hand as a corporate entity, we would follow up. The ladies will come to you, you give us some details, and then you find us in your offices. The bar has to speak for the bench on this occasion. And therefore, please, by show of hands, just raise your hands. We'll move to you, and then we can have a good conversation based on these projects that we want to carry out. Ladies, are you ready? Do I see some hands up? Do I see some hands up? Corporate entities. Okay. Presence is not here. Who else is available? Police. Police is here. Police has given me a signal, a very diplomatic signal. So please move to the police. Yes, can I have other persons, just by show of hands? The ladies will come to you. We heard from the Gbese Manche. He said he was going to help us in all our endeavors. Please, who is coming to the Honorable Gbese Manche? Ladies, yes. Please, who else? Can I see some hands? To my left. Are some hands going up? Where's the Honorable Deputy Attorney General? The Honorable Deputy Attorney General. We know our way to his office. It is at the Law House. And also the Deputy Chief of Staff. We know our way to her office. She happens to be my classmate as well, from Wesley Girls. Yes. I spoke about the corporate entities, but there are some individuals here. There are some individuals in our midst. Even before we came here today, there were some persons who had already decided to assist us in this regard. So please, the individuals, the law firms, please join in. Each law firm can decide. Those in Tema who are here, we ought to bless you with a court complex. So please raise your hands. Raise your hands. I see the ladies moving around. Can I have some more hands up? Can I have some more hands up? It's about time that we make a difference. Okay. Now, what we are going to do subsequently is that all the gentlemen and ladies in an apparel such as mine, the Solicitor General is here, other members of the Planning Committee, we are all here. We are not in a hurry to leave this place. So we dressed this way so that we can be identified. Please come to us and let's have a chat. This is the beginning and we are going to move on. I trust that you help us to make Ghana proud that it has, as a result of its 150th anniversary of the Supreme Court established in Ghana, done this to the glory of God. I would end here. Time is fast spent. Thank you very much.
Thank you very much, Mrs. Ifuagate, a member of the Planning Committee, for this celebration. I believe that we will all dig deep and support a worthy cause. It is now time to take the closing remarks from the chairperson for this august occasion. Let's welcome Her Ladyship, the former Chief Justice, Sophia Akufu.
My Lord, Chief Justice, Justices of the Supreme Court, all protocols duly observed. I like this aspect of being chair of a function, because at the beginning you don't have anything to say, and at the end, after so many brilliant deliveries, you still don't have anything to say. Because if you try to repeat what everybody has said, you will be stealing thunder and you will simply be boring people. Therefore, I will just say a few words to wrap up
such a wonderful morning and early afternoon that we have had. I'm not going to summarize any message or any address. I'm just going to say that when listening to what everyone was saying, something crossed my mind that if a subheading was to have been written into the chapter on the judiciary, I think Article 37(1), the words probity, transparency, accountability would be what should be written as subheading for the judiciary, because that sums up what the judiciary of Ghana has stood for, still stands for, and into the future must stand for. Because if everything that one does, there is probity about it, justifiability about it, truth about it, integrity, independence. If there's transparency, everything is out there in the open. And there's accountability, responsibility. That's what justice is all about. The Right Honorable former Speaker, Prof. Okwe, reminded us that he reminded us of the attributes of the good judge. And it is simply that the good judge is exemplified by God himself. It's an onerous responsibility to be a judge. And every day when you look at yourself in the mirror, you ask yourself, am I worthy of the robes I'll be putting on today? And then you say a prayer committing your day into the hands of God. That is how I believe it has always been. That is how it must be today, and that is how it must be going on into tomorrow. One final thing I just want to also say is that when you're celebrating the good things of the past and taking stock of now, getting ready to look into the future, you must, and I'm happy there's celebration going to go on. When something good has been done, it is worth celebrating. And when you celebrate, you then develop what you're going to be doing going forward. So people won't say, they did well up to now, and now look at them. This is not the lot of the judicial service of Ghana or the judiciary. So there are a few things we must keep bearing in mind. One is having achieved much so far, despite all odds. Going forward, there's the challenge, and challenges are good, and challenges are a blessing in disguise. And in meeting challenges, one has to make sure what are we going to be looking at? We be looking at continuing to be fit for purpose. Fit for purpose. The purpose being the intended, the expectations of the reasonable generality of the public. Fit for purpose as an institution that stands on a stable platform of constitutional growth, constitutionality, constitutionalism, credibility, independence, integrity, competence at all times, and relevance, which is also effectiveness. Effectiveness is what makes the public continue to respect judicial delivery. As we've been told, all we have is the judgment. That's all we have. And that is also something really formidable and really valuable for the nation now and well into the future, because it is on that assurance that the nation can even exist. So one thing we should be constantly looking at is the quality of legal education. And legal education must be focused on quality more than on numbers. That is always important. So if now that there's a new law coming out, let us hope that it is going to strike the proper balance so that there's going to be quality assured, whilst at the same time giving the numbers. But if you have to sacrifice anything, sacrifice the numbers for quality, because quality justice is more valuable than 1,000 and 10,000 and millions of lawyers who are of low quality. So we must assure the public quality lawyers, because quality lawyers are the people who will become judges, and quality lawyers will then become quality judges. And that is all that a nation can hope for. And we must be very innovative in this world of IT, ICT, AI, and whatever else will be happening, because we must not be left behind. We must make sure that with AI and every aspect of technology, we adapt, we innovate, we adopt, and we reimagine, constantly reimagining how best the judiciary can do what it does best. So I'm really looking forward, personally, I'm looking forward to the celebration as it rolls out throughout this year, and I hope you will, the judiciary will keep those of us, the ex-people, you will keep us in mind and find out if we have time and energy and strength to participate in the celebrations. And we will do our part and support all that is being done, at least with our prayers, and those who have money will support it with money. So I thank the organizers of today's event. You've done very, very well. And I thank every person who has spoken today, because you have enriched us. And yes, the messages and the addresses must be published somewhere, because it's good for those who want to remember, it's good for those who are learning, and it's good for the future. So upon that note, I wish to thank you all very much.
Thank you very much, Madam Chairperson, for the expert steering of today's event. We shall now call on Miss Gifty Prekunyako Esquire to give us the vote of thanks. And as she turns up, we wish to acknowledge the contribution and the coverage that we have received from our media partners: Joy News, GTV, UTV, GH1, Star FM, 233 Legal. They were streaming live as well, and we are grateful to all of them. Also, Amayao Deborah 1957. We are thankful to all these news outlets for prioritizing today's launch.
Respectfully, my Lord Chief Justice, representative of the President of the Republic, the Deputy Attorney General, former Chief Justices, the chairperson of this occasion, Her Ladyship Retired Sophia A.B. Akufu, Justices of the Superior Courts, the Judicial Secretary, Honorable Michael Okwei, other special guests of honor, judges and magistrates of the lower court, Nananom Nime Name, the President of the Ghana Bar Association, the Director General of the Ghana Prison Service. I acknowledge Sheikh Arimeya, representative of the National Chief Imam, and may I respectfully also observe all existing protocols already established. I am deeply honored and privileged to stand before a gathering of such distinguished personalities to deliver the vote of thanks for the launch of the 150th anniversary of the Supreme Court of Ghana. I stand before you not merely to perform a ritual of thanks, but to capture a moment of profound legacy as we bring this launch to an end. Cicero aptly said that gratitude is not only the greatest of virtues, but the parent of all others. First, I wish to extend our deepest appreciation and gratitude to the Honorable Chief Justice of the Republic of Ghana, His Lordship Justice Paul Bafuboni, for his visionary leadership and for being the grand architect of what we have all experienced today at the launch of this 150th anniversary. My Lord, we thank you. My Lady Chairperson of this historic event, Your Ladyship Justice Retired Sophia A.B. Akufu, the 13th Chief Justice of the Republic of Ghana, and a distinguished stateswoman, we wish to thank you most profoundly for steering the affairs of the launch to this successful end. My lady, you did this with such wisdom and grace. To our distinguished members of the Judicial Council, the Judicial Secretary, representative of the President, Deputy AG, our guests of honor and guest speaker, we say thank you for gracing this occasion with your presence and for delivering such inspiring addresses, which has lent unrivaled dignity to this occasion. We truly appreciate your reminder that this anniversary milestone is not a destination, but a vantage point from which we can all appreciate both the legacy left behind by our forebearers and the duty that lies ahead for us within dispensation. Our lordships of the Supreme Court bench, may I say this is our day. This day is uniquely yours, and you did not just show up, my lords, but you all came with the flame of justice burning brighter. Your presence is not just to mark a significant milestone of the judiciary, but part of a living legacy of resilience, integrity, and service to justice. You have proved your forebearers that their labor was not in vain. You, my lords, have historically validated the legacy of the Supreme Court of Ghana today. And this remarkable gesture will leave high standards for future jurists who will read commentaries and articles of this launch. Maybe another 150 years from now, that you held the line, you celebrated with dignity, and you passed the torch responsibly. Our distinguished guests, Superior Court judges, distinguished Minister of Justice, Justices of the Superior Courts, honorable representatives, I salute you all. We owe you a debt of gratitude for your presence. In a world of silos, you have shown us a symphony, and we greatly appreciate you all. His Majesty, Royal Majesty, the Gbese Manche, our landlord that has hosted and will continue to host the Supreme Court of Ghana on his land, we deeply appreciate your distinguished presence at this launch. Nananom, Nime, Name, your role in our pluralistic legal system is not lost on us. As the African proverb says, if you want to go quickly, go alone. If you want to go far, go together. Today you have shown that we are determined to go far together. We also acknowledge with deep appreciation the presence of the clergy and the representative of the National Chief Imam who graced this occasion. Thank you so much. To our distinguished members of the Diplomatic Corps, members of the bar, leaders from every pillar of the justice sector, directors and deputies of the Judicial Service of Ghana, association leadership of the Judicial Service, registrars and staff, the police and other stakeholders that I have not been able to mention due to the brevity of time, we say a big thank you. The judiciary has survived 150 years, and we have been strong because of your commitment to the cause of justice. The coming years, we believe, will be unshakable because of our unity, which you have demonstrated by being here today. We recognize also the various law faculties here in present. Please give me a wave. Thank you very much. And the Ghana School of Law and student body representatives here in present. I wish to specially mention the members of the 150th Anniversary Committee, my own committee, led by our indefatigable Justice of the Supreme Court, His Lordship Justice Richard Ajay Frimpong. My Lord, thank you for your remarkable leadership, which has transformed this launch into a landmark event. Honorable members of the Planning Committee, please give me a wave. Thank you so much. You worked tirelessly behind the scenes to produce a result so sterling, for which posterity will forever remember and will forever thank you for. Your collective wisdom has been the bedrock upon which this celebration stands. I say Ayiko. To the media, our own Judicial Service Press Corps, thank you for capturing and recording this event and not making this launch just a passive memory, but an enduring testament for unborn generations. Your work begins now, and may you continue to trumpet the celebration. Our honorable MCs, thank you for a job well done. I humbly wish to reiterate that the launch today is just a curtain raiser, not the finale. Thus, even though this launch is complete, the celebration has just begun. We seek your support in ensuring that all planned activities are implemented successfully, and we will knock on some doors for some money as well. As we ask for your blessings today, we will return tomorrow asking for your involvement. 150 years of the Supreme Court of Ghana is rare, but to witness it is even rarer, and to be part of the launching of its celebration with such an august gathering is almost sacred. Let us leave here not with the satisfaction of an event concluded, but the resolve of a journey begun. Thank you for making the launch truly unforgettable. Thank you.
I think this one is part of the speeches. It will go into the review of Ghana law. Thank you very much for the Thanksgiving, Mrs. Preku. We're getting to a close. But I must say that in answer to the launch for thanks by the President of the Ghana Bar, the Inspector General of Police has offered a dynamic 20,000 Ghana cedis, ladies and gentlemen, and he deserves applause of all and sundry. That is the curtain raiser. It sets a beautiful pace, and I expect that would emulate the solid example of the Inspector General of Police. We are grateful to you, Inspector General of Police. 20,000 cities. Should I wait for more? Should I wait for more money? Thank you very much. Ladies and gentlemen, we would call the Arimiao, you deliver the prayer in Islam. I think I chipped in some Islamic words at the beginning of the whole project. I don't know whether they were correct or they were double Dutch. Arimiao knows what to do in Islam. Thank you.
Please, after the closing prayer, let's wait for the photographs, please, especially the invited guests. Thank you.
My Lady Chair, the Honorable Chief Justice, may I take this opportunity to convey to you the profuse apologies of the eminent National Chief Imam, who was invited but could not come and has asked me to represent him here, and also extends to you his warmest felicitations and best wishes in the occasion of this celebration for more than 100 years, specifically 150 years of existence of our judicial system. It's no achievement. Now I can say my prayer. Bismillahir Rahmanir Rahim. Almighty Allah, Almighty God, I want to give you thanks and praises in a manner most befitting of your holiness and highness. Thank you for this day, and thank you for all the speeches that we've listened to this morning. Thank you for inspiration. Thank you for guiding our judicial system, Supreme Court, for 150 years. Thank you for the attainment of yesteryears. Thank you even for the challenges, and thank you for reformations. Thank you for guiding us. Almighty Allah, we have come here just to do a curtain raiser for this celebration. We ask you for the gift of life and gift of good health that we will live to see the beginning of this celebration, and give us the ability to even appreciate all the kindness that you have done to us. Inspire us as we in celebration to be more committed, to re-establish our commitment to the pursuit of justice. Let us be conscious of that justice is part of your attributes, uncompromising, and that which you expect us as humans also to give application to, such that through our justice we'll keep the peace and harmony of our communities and the world at large. Bless all our justices from the lowest level to the highest level, and those who are in office, continue to inspire them, give them the courage, the gift of integrity, honesty, sympathy, care for the weak of society who need justice the most. Help them with good health, soundness of mind, soundness of justice, and bless them in every step that they make as they meander through this tortuous path of ensuring that there is justice among human community. Bless our nation, Ghana. Inspire our leaders with the best of ideas, translate into policies that brings happiness, peace, prosperity. Bless every home. Bless every family. In the world wherein there is no peace, we ask you to grant them peace across the world. So in the manner that as Ghana we experience our peace, all other nations will experience peace. Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Ar-Rahmanir Rahim. Maliki Yawmiddin. Iyaka na'budu wa iyaka nasta'in. Ihdina as-sirata al-mustaqim. Sirata alladhina an'amta alayhim. غير المغضوب عليهم ولا الضالين. آمين.
Thank you very much, ladies and gentlemen. We will take our photographs and then we will have the reception. Our special guests and the retired Chief Justices will be ushered into the holding room. And then the rest of the reception will be held in the foyer. So please, let's take the photographs now. We will have the Chief Justice take a photograph with former Chief Justices present and retired Justices of the Supreme Court. Please, the Chief Justice, retired Chief Justices, and retired Justices of the Supreme Court. Please, may I kindly ask you to remain seated because of the photography. Please, kindly remain seated. Kindly remain seated. We need the space in front of the auditorium for the photographs. Please. Are they taking the photo? Please, a photograph. The Chief Justice, former Chief Justices, and retired Justices of the Supreme Court. Okay, so we'll take the remaining photographs up here on the platform. Are you done? The Honorable Chief Justice, retired Chief Justices, and retired Justices of the Supreme Court of Ghana, kindly take the photograph. Please, all retired Justices of the Supreme Court, join this photograph. all retired justices of the Supreme Court, please join this photograph.
Something.
Okay, so please, we continue with the remaining photographs. We'll kindly ask the Chief Justice and the retired Chief Justices to take this one up here with a backdrop. The Honorable Chief Justice and retired Chief Justices. No, we are coming here. That's the first one. The CJ and the... Yes, ma'am. It's an order, so we are calling. That's why we said you should sit. Because you will be called, so. Yeah, we. So, if we can. Your Ladyship, Justice Sophia Kufu. Madam Chairperson, if you could kindly join the Chief Justice upstairs. I know. Then we should forget it. Your Ladyship, Justice Theodora Georgina Wood. Your Ladyship, Justice. Please. Call me. The VVI, please, may we invite all Supreme Court justices to join. All Supreme Court justices, please come upstairs for this photo. All Supreme Court justices.